Hello neighbor, I'm Robert Burns and welcome once again to another edition of Sound Off Louisiana. And we're going to cover two cases today, and just very briefly in the way of housekeeping with regard to the John Stelly, Louisiana State Police Lieutenant John Stelly's reverse discrimination case that is taking place in federal court in New Orleans. When we last talked to you, he was going to have to engage in a settlement conference, a mandatory settlement conference on Monday of this week, and I'm just going to let you know that settlement conference was had and it proved fruitless. We'll give you the document for that, and so the only other thing of significant note in that case that has transpired is his attorney has asserted that the LSP attorney made a completely frivolous filing in seeking to have the vast majority of the evidence that was introduced as in the opposition memorandum to the motion for summary judgment. She wants to have that removed, stricken, and he basically said that was a frivolous filing. She has responded to that. She does not feel it is frivolous, so that will be up for the judge to sort out, and I believe the court date on that is around, don't hold me to this, but I believe it's around August the 23rd, give or take. But I want to move on today to a trial that we will be covering in pretty much daily detail, and that is the matter of the Stanford Trust. Now, for those who are not from the Baton Rouge area, you may not be familiar with it, but back in 2008, everybody remembers the Bernie Madoff fraud. That was a Ponzi scheme in which investors lost approximately $50 billion. And kind of somewhat lost in the shuffle of that was a similar case that happened here in Baton Rouge. Everything got exposed in 2008 as a result of the financial crisis. We had a gentleman named Alan Stanford who had basically solicited investments and certificates of deposit. And it too was a Ponzi scheme, and investors in and around the Baton Rouge area in southeast Louisiana are alleged to have lost approximately $7 billion. And I'm going to just briefly tell you what went on in it. I mean, very briefly. They would issue certificates of deposit based upon a offshore bank in Antigua. And and it wasn't just Stanford himself. There would be brokers from Bear Stearns and Merrill Lynch. And the vast majority of victims in this Ponzi scheme were retired workers from Exxon. Not all of them, but many of them were retired workers from Exxon who literally rolled their entire retirement savings into these vehicles only to find out in 2008 that it was literally worthless. It devastated many lives because what would happen is that he would promise a return that was only a little bit higher than you would get in a traditional bank for the certificates of deposit, but rates were low, and so if someone could get 7.5 versus 4.5 at the bank, they thought that was doing well. Not to mention that the representations were made that these things were insured by the FDIC through what he referred to as, quote, FDIC excess. Well, many of you know my past history is I was a federal bank examiner for the FDIC, so I have a keen interest in this trial. It has taken 16 years for this matter to come to trial. And there have been some other parties that have settled, specifically TD Bank in Canada has recently put up $1.25 billion in order to be removed from any litigation. And the receiver in Texas, Mr. Ralph Janvey, has recovered some money, not a lot. Mr. Stanford is in prison. He's in federal prison, I believe in Florida. But this has been a tremendous heartache. And some of the folks I saw in court today, some of the folks have died because this has dragged on so long. But I saw some folk in court today who were quite up in age that fell victim to this, and it is a very sad thing to see. And having said that, while my sympathy is certainly there for them, I'm going to have to maintain the objectivity of reporting on this, and also to distinguish a few things as to why things may go the way they go. And one of those things is that very early on, the SIPC, Securities Investors Protections Corporation, did offer each member of the class action $250,000, which was a little shocking to me, because the SIPC, this is not what they do, okay? The SIPC insures against the existence of securities, okay? That's it. So the reason, and because these people were very upset that the Madoff victims did get $500,000, that's the limit of the insurance, and they were not going to get anything. And the reason for that is, in the Madoff situation, he was purporting that, for example, on your statement, it may show that you have 2,000 shares of IBM. Well, you didn't have those shares, okay? And that's what the SIPC protects against, the existence of securities. In sharp contrast, the Stanford situation, you got a certificate of deposit, okay? You got your security. The SIPC does not insure the value of securities. If they did, they would go broke in no time flat. In fact, I would like to make a claim for an investment I made in Circle K way back when Exxon and all of them started to expand into the convenience store outlet. What do you think happened to my investment in Circle K? Now, fortunately, it was not a large sum of money, but I'm making that point to say that's why you make the distinction. So the SIPC was really not on solid ground, solid legal ground in making that $250,000 offer. It didn't matter because it ultimately was rejected. While many may have wanted to take it, you have to realize there are people that have lost $2 million, $3 million, their entire life savings on this. And the SIPC, from my recollection, it's a long time ago, said we're not going to have this thing piecemealed. It either needs to be everybody on board or we're not going forward. Well, and there were some who said, look, $250,000 is just not enough. We want the whole $500,000. And so the matter went before a 3-judge panel in Washington, and the ruling was that the SIPC is in no way liable for this, so everybody got zero. So I'm going to just give you the high points of what took place in the trial in these first 2 days, because I just gave you an overview of what happened and the regrettable situation that we're in. We have not even made it to opening arguments yet. The trial started yesterday. The jury selection process took basically a day and a half. It was not until roughly 1 o'clock today that the final jury that was selected was in theory ready to start hearing the case, but because there was a lot of arguing going on between the attorneys, even today the jurors did not begin to hear any. We have not had the first witness called. So I'm just going to briefly just say that I've been to an awful lot of courtrooms, observed an awful lot of trials, and every time I go I always say, okay, nothing's going to top that. Well, something has topped it on this one. One of the prospective jurors, I wrote down the name of Russell, I believe, and I assume that's the last name. He was brought forward, and this is an approximate 22 to 25-year-old black male, and Judge Johnson said, okay, what is your occupation? And he said, well, I'm a drug dealer. And so the courtroom busted out with laughter, and so Judge Johnson said, well, now, legal or illegal? Well, he was honest enough to say it was illegal drugs. And so Judge Johnson said, all right, look, you're going to be excused from this jury, but you need to report to the jury pool for the coordinator of it to give the final release from any summons. Well, apparently that individual told him he needed to report back the next morning at 8 o'clock, and he did not report until about 10 or 10:15, She sent him up to Judge Johnson. Judge Johnson, when he saw him, said, "Mr. Russell, I need you to approach." And he basically told him, "Look, when I released you yesterday, it was because you told me you needed to go out and earn funds for your family." He said, "You did not tell me that you were going to leave this courtroom and go out and resume the kind of nefarious activities that you told me was your profession yesterday." And he said, "Look, I'm going to have a man-to-man, heart-to-heart talk with you." And he basically told him, "Look, don't ruin your life. Don't throw your life away. You're going down the wrong path." And the young man, I could not make out what he was saying, but apparently he said, "Oh, I understand, Your Honor," and so forth and so on. So he was excused for good. But, every time I go to a trial, it's like, okay, what can happen that hasn't happened before? And once again, a bizarre thing. A man admits to being a drug dealer as he's going through the jury selection process. So, the other couple of things with regard to what took so long today is, well, there were two things. I'll cover the easier one first. The plaintiff's attorney, Mr. Price, apparently ran into a gentleman by the name of William Menard. I don't know how long ago, but he ran into him in a grocery store, and Mr. Menard said that, "Oh, well, you need to subpoena Jerry Newport." He was legal counsel for OFI. He said he's going to give testimony that's going to be very adverse to the Office of Financial Institutions, which, by the way, is the defendant in this trial. And one of the reasons that I'm so going to be laser focused on this trial is because I worked with these people side by side with OFI when we would do joint bank examinations. In fact, I remember the name Gary Newport. It's been a long time ago, but and so because this is what I did as a fraud examiner for the federal government, I have more than a slight interest in this case. So at any rate, he said he will be able to provide testimony that is adverse to the OFI. And the defense attorneys for the OFI, Office of Financial Institutions, who are represented by Phelps Dunbar, a powerhouse law firm, and they have about 5 attorneys defending this, they obviously objected because this subpoena apparently had been served days before the trial. And so they said, "Your Honor, this is most improper." They filed a motion to quash the subpoena. And I'm going to kind of cut through, because this took an hour or more. But when push came to shove, Mr. Newport was put on the stand, and he had said that he certainly knew Mr. Menard, but he was now dead. And of course, then the defense attorneys object. So now we're being asked for him to go into the mind of a dead man, because he adamantly denied that he had ever told Mr. Menard that, hey, if they subpoenaed me, I would be sympathetic to the plaintiffs here. He said, I never had any discussion ever with Mr. Menard. Now, we have one man that's dead, and we have another man that had started to work at OFI in 1968. So by his own admission, he's getting up in age, which was very obvious. And so before he was released, because this did become almost a complete 3-ring circus, he was asked to view one document that was dated 20 years ago. It was an attorney from the Jones Walker law firm that dealt with Stanford activities, and he said, well, does this letter refresh your, and it was written to Mr. Newport, he said, does this letter refresh your recollection at all? He said, not in the least. So pretty much he's been released and will not be, barring any really unusual circumstance, he certainly is not going to be a witness in this trial. So the only other major thing, and this took hours, is the two sides are arguing over what level has to be proven on the part of the OFI. Everybody agrees it's more than just ordinary negligence. but they are fighting over whether you're going to have to go all the way up to the bar of gross negligence, or whether or not reckless or willful indifference. And I understand that this may seem minor, and for the jury, they may not be able to distinguish, but I would imagine that whatever side loses here is certainly going to appeal. And let me just say this. The OFI was seeking to not allow its work papers to be shown to the public. And that was a sticking point. And so the First Circuit Court of Appeals ruled on Friday. They agreed with Judge Johnson that those work papers could not be viewed to the public, which had really frustrated me because I want to see those work papers. I want to see what's in them. I want to see what got said. And so Mr. Price appealed that to the First Circuit. The First Circuit agreed with Judge Johnson, and so there was an emergency writ submitted to the Supreme Court of Louisiana. That was considered over the weekend, literally on Saturday, and they reversed the First Circuit and said that these work papers would be available to be shown to the public, and the courtroom would not need to be cleared. I obviously was very pleased to hear that. I agree with the Supreme Court that the right to observe legal proceedings takes precedence over any perceived confidentiality of those work papers. But that is that. Oh, by the way, to resolve the matter of what level it's going to have to rise to with regard to the OFI, Judge Johnson instructed both sets of attorneys to draft. All this has got to do with the instructions to the jury, and specifically page 10. And they're wanting to get resolved what level will OFI have to rise to, what level does the plaintiff have to prove. And so Judge Johnson asked them both to submit their briefs by tomorrow morning on what they want inserted in the language that's in controversy about the instructions to the jury. And he indicated that he would make his ruling tomorrow morning prior to the convening of the jury, which will be at 8 a.m. tomorrow morning. It's my intent to come after each day and to give a little recap. I've tried to do my best in doing that today and not keep it any longer than I would absolutely have to. I think this is going to be an interesting trial. It will probably have the interest of a number of folk. I think Mr. Price was probably hoping that the courthouse would be considerably more packed. In fact, they put it in the biggest courtroom. And I can only tell you that there's only about 20 or 25 people, and that included prospective witnesses that will come up to testify to their losses. And I think the reason for that is fairly simple. It's that you have to realize this thing is now 16 years old, and most of the recovered money, which a gentleman volunteered to me, they've recovered about 9 cents on the dollar. And I don't know if that includes the $1.25 billion settlement with TD Bank, but the receiver in this and all of the labor and such, that racks up an enormous tab. So it's not surprising to me that only 9 cents on the dollar has been recovered. And the reality is that even if the OFI is found liable here, let's just say $250 million, but which is an enormous amount of money. But when you're talking about suing a state agency, beyond just getting the judgment, you then have to get a bill filed into the legislature to pay the judgment. And many of you may recall there was flooding in 1983. It was a massive flood that precipitated the need for the Comeet River Diversion Canal. And I can just tell you that those 1983 flood victims finally saw their money about 4 years ago, 3 or 4 years ago. So you're talking about 17 plus 20, that's 37 years. And they were willing to forget about any accrued interest, because, I mean, what good does it do to come into money if you're dead? And an awful lot of folk were dead by then, and it went to their estate. So perhaps the level of interest in this trial is kind of like the final little shebang, and isn't gonna amount to a huge amount of money, even if the plaintiffs prevail. And bear in mind, there's still that hurdle to get a bill through the legislature to pay the judgment if, in fact, OFI is deemed to be liable. And if they are, by the trial court, I can assure you it's going to be appealed to the First Circuit and then probably ultimately to the Supreme Court. So this is going to be a very, very long and drawn-out matter, especially when you factor in the need for getting a bill to fund, even if it is ultimately upheld all the way to the Supreme Court. I will be very honest, I think the plaintiffs are going to have a pretty high burden in this matter because OFI I will be interested to see through what authority they would have had to take action on this, and that's what they're contending. We couldn't take action. Now, it'll bring an interest. The reason that they're alleged that they could take action is because these were securities being sold within the state of Louisiana. Therefore, OFI had jurisdiction, and Stanford did pay premiums to OFI, and so Mr. Price and the plaintiffs are contending that they have an obligation to nip this in the bud, and they knew about it and didn't do it. I think that's going to be a pretty high burden, but that's just my assessment. I've not seen the evidence that will come out in the form of work papers and testimony, but I will say this, if Judge Johnson rules that Mr. Price is going to have to prove gross negligence, that is a very high burden. That's why these attorneys argued for a couple of hours today about what level is going to be required. I will give you daily synopsises of the court proceedings as we go through, as I tried to do today. I want to thank you for having tuned in. For the next 2 weeks, I probably will, well, it's not probably, there's only one feature I may put out that won't pertain to this trial. I guess that's the nice thing about having a blog. I get to report on the matters I want to. There's no editor telling me, go here, do this, do that. I also don't get paid, but I do enjoy what I do, and I want to thank all of our many loyal folks that have tuned in over the last 9 years of this blog. So look forward to bringing you the next day's coverage of this Stanford trial sometime late tomorrow evening, and thank you once again for your dedication.